Pokemon has had their patent rejected by the Japanese Patent Office. This is a giant win for Palworld and a huge step in their lawsuit between Nintendo, Pokemon Company, and Palworld, and their attempt to dominate Pokemon and Nintendo, their attempt to dominate the Pocket Monster genre. Of course, we're going to talk about that in the Legal Mindset. We teach Be Your Own Judge. I'm Andrew Esquire. This is a fast facts version, the quick and dirty version of the latest in legal news. If you like this format, make sure you like the video and leave a comment below. So let's get right into it. Let's get my PP right here. The Pokemon patent rejected. So let's talk about this. As background, obviously, Nintendo and the Pokemon Company International are engaged in a vicious lawfare campaign against Palworld to corner the entire Pocket Monster genre. So they're trying to go after this entire genre, and they're trying to lock this down entirely. The lawsuit is for patent infringement, not copyrights. That's an important distinction. Oftentimes people go back to the character designs and go back to, okay, this character looks like this one. Well, that's not actually what this is for. What this is for patent infringement, which is for the actual mechanics that underlie the systems. So saying, hey, this system is similar, that's the problem, not necessarily the design or the art. Now, of course, some of the art does play into certain elements, and we'll get into that. But the case is currently in the Tokyo District Court. This is a Japanese case, although there are related U.S. patents, and obviously what happens in the U.S. is related to that. But the patents generally in Japan are reviewed by the Japanese Patent Office, the JPO. So I'm going to be using that term, JPO. So the JPO recently, just now, rejected one of the Pokemon patents, we'll talk about that, as lacking an inventive step, essentially saying, hey, this is not doing anything new. This is doing something that has been done before. And the Patent Office themselves cited older games such as Arc, Monster Hunter 4, Craftopia, Kantai Collection, shout out there, and Pokemon Go itself. Literally, Pokemon got owned by Pokemon Go. That's how bad it is. That's how bad it is here. And it suggests that Palworld isn't just copying Nintendo or Pokemon, but there's decades of established game mechanics that are underlying what's going on here. So this complicates Pokemon's situation greatly, as another patent was derived from this denied patent. This is what I've called, what we've talked about in this channel as divisional patents. I talked about this previously in my coverage of Pokemon versus Palworld, and this is a legal strategy. So I know this looks complicated and there's a lot of kanji here, but what you got to pay attention to is this is the one that was denied. So this patent was denied. Why is that important? This is important because there's another patent that was divided off of the one that's denied. So now this one that was divided off is under scrutiny, right? So this patent has been denied. This one's gone. So now this one definitely in trouble. And even this one, the parent patent, you got to go back and ask some questions. Wait a second. Is this completely legit? Because if this part of the patent is illegit, then maybe a larger part of this is not legitimate as well. So there's a lot of questions this brings up as to the legitimacy of the other patents, right? Is it a silver bullet that takes out everything? No. Does it severely damage their legal strategy, and does it send Pokemon looking for excuses and looking for other things? Yes, absolutely it does. So this is a pocket pair W without any holding it back at all. And the interesting thing, and this is a very fun unknown factor, and perhaps we'll get confirmation one way or another at some point, but there was a mysterious third party. We do not know whether or not it was Palworld, right? Whether it was pocket pair. We don't know. It probably was, but we don't know. They filed examples with the JPO, the Japanese Patent Office, of prior artwork. And the Japanese Patent Office let everyone know that it was the filing of this prior art which led to the rejection of the patent. This is excellent. So this gives us a template for fighting Nintendo. So whenever Nintendo files these patents, well, people can go, third parties can go to the Japanese Patent Office and, give them proof. Say, hey, here's why you should not grant this patent, because they're just absolutely picking off the past. This is nothing new. And this definitely opens up the scrutiny of other Nintendo patents, not even just Pokemon, but just more broadly Nintendo. There's probably a lot of mechanics that they're trying to lock down in general, overall, that they really don't have any right to. And there's an extensive list of games that use the same mechanics, which Pokemon is trying to monopolize. We had Ark, Tomb Raider, Zelda, Titanfall, Rune Factory 5, and those are ones that were cited by Palworld, that even Palworld brings up. But Palworld also argued that mods are also a good reason why there's prior art that should be considered. And, you know, that's something that I think is very, very important, especially since Nintendo refuses to acknowledge mods as art, right? So they're saying, hey, mods are not actually art. They're something that is that is really just derivative, and therefore we're not going to actually allow that. And if you're asking, am I updating my PowerPoint due to typos in mid recording? Yes, I am actually doing that. Okay, so there we go. Got it back there. So yeah, Palworld's arguing that mods like Pixelmon in Minecraft, Nukamon, Fallout 4 prior art, and Nintendo refuses to confirm that mods are art. Of course, the court is not going to care whether or not they confirm that or deny that. Nintendo can say whatever they want to say. They're going to look at that, the court, and it's going to say this has been done before. And that's the lack of an inventive step. And that's where they got in trouble in the past, and that's where a lot of their other patents can also have issues. In a conclusion, Japanese judges are going to defer strongly to the finding of the patent examiners. So the patent examiners are really the ones that are the technical experts or the specialists. So that's not good for Pokemon. The judges are not going to strongly go against the JPO unless there's a strong reason why they should go against the JPO. Pokemon has already modified one of their patents during the middle of the lawsuit. That is extremely desperate. Imagine that. You're in the middle of a lawsuit, and the whole point of the lawsuit is the validity of the patents and patent infringement. But how is the judge supposed to decide what's been infringed upon if even you don't know what's being infringed upon? Think about that. You're like, well, what is it that you're actually suing for? And you change the whole basis mid-suit. It just doesn't make much sense. So that's what's going on here. Now, Pokemon is also, and this is the rumor, the scuttlebutt, and I know the Pokemon people will be crawling out of the woodwork to comment on this one, but Pokemon is likely preparing a survival-style, Palworld-ish spin-off, which is why they're trying to monopolize the genre, because they're not creative, because they're not doing new stuff. What they want to do is knock off Palworld and have the right to do that because they've kicked Palworld out of the market. What they want to do is be a cheap Palworld knockoff, right? And try to take over that side of the market by kicking out Palworld, because Palworld's already proved their concept. They proved that's a viable concept. So now they're trying to come into that market. I don't think that's smart. I still think that the best conclusion is still an amicable, a friendly settlement between Nintendo, between Pocket Pair and Pokemon Company International particularly. And I think that is all in the hands of Nintendo and the Pokemon Company. They're the ones that could decide to settle this, to end this, and that's the way it should go. But let me know what you guys think is going to happen in the comments below, and I will catch you on the